This morning on the Ag Issues program, as we do every couple of weeks on Mondays, we talk about ag law and tax laws as well. Joining us to do that in studio this time, we're changing it up when we used to do it. Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us in studio this morning. Roger, good morning. How are you?
Good to be with you, Greg. Just fine.
Well, let's get to it. And I'm sure you get this question a lot, but is it safe to say the least that, the calls, the emails that you get, it's on a whole, pardon the term, potpourri of ag law and tax issues that you experience and see and work on? Yeah,
that's certainly fair to say. For example, just the other day, the phone started ringing before 6 a.m. Because I give out my cell number if people need it, and some take advantage of that, and that's when farmers can get a hold of me, and I can get a hold of them before they get busy in the day. And it started out with a bankruptcy question, then we went to an easement question after that. Then after that, I had a lease question, and right after that, then I had another property-related question, and then a contract question, and that's before I ever got to the office. And you could repeat that not every day, but many days are like that.
I bet.
And I had, of course, on my list things I needed to get done, and I got to them about 1 p.m. I got started down that list.
But that's
typical.
Yeah, I just say it's more typical of your day.
But that also is a product of 30 years plus of being in K-State Extension, and you make yourself available to people when you're in Extension. That's what you do.
All right. Well, let's get to what we want to discuss today. And the first one that we want to talk about has to do with prepaid farm expenses and death. And, boy, that's an issue that I know many families or many ownerships have gone through, too.
Well, a lot of cash-basis farmers will prepay expenses. It's a tax planning tool. I'm going to buy my inputs for the next spring crop in the fall of the previous year. Right after perhaps I've harvested that crop, when I've got the money on hand, I'll go ahead and prepay next year's expenses. And this was a big deal a few years ago, right before we had the run-up in fertilizer prices and so forth. So I'm going to buy my seed, my feed, my fertilizer for the next spring, lock in that price, lock in a supply, and then I'm going to use that to put my crop in the ground next spring. And many farmers do that over and over and over, and they'll also defer income. So we're prepaying expenses and deferring income. So we get on that treadmill, so to speak, and it's tough to get off of that.
So it's so many things that need to take place, so many things that can go right, can go wrong. Mm-hmm. Yeah, and it all depends on how. I assume it's all depending on how it's set up, too.
Well, it is, and people don't always time their deaths appropriately and die at the right time or in the right order, and it creates issues not just in estate planning, but what if you prepaid all of these expenses? And what I'm referring to is a case that occurred in late 2016 out of Nebraska, south of Lincoln, kind of halfway between Lincoln and the Kansas border. And I actually got the call on this from the attorney that had this farmer, and he was battling with IRS over this, and he said, I'm racking my brain over this. And in fact, I was in between two tax schools for K-State, and we were on our way to Wichita. My wife was driving, and he gets a hold of me in the car, and he said, Roger, I can't see where I'm wrong, and that's what scares me. If I can't see a flaw in my argument, I'm feeling that I just completely missed something. I said, well, what do you have? He said, well, I had a farmer that bought $235,000 worth of inputs in the fall, and he was going to use those to put his crop in the ground the next spring. And we wrote him off on his return. He died after the return was filed, deducting that, but before he could use the inputs. And so his wife succeeds to the farm. Everything goes to her. She takes over the farming operation and uses the $235,000 worth of inputs to put the crop in the ground, and we deducted it again on her return. The IRS, their head exploded. They said, I think that's right. I said, yeah, you're exactly right, because what happens is that because he hadn't used those at the time he died, it becomes inventory in his estate at death. It's included in the estate for tax purposes, and Nebraska has an inheritance tax, so it's in his estate for state inheritance tax purposes. Basis step up, goes to mom. She runs it through the tax mill again. I said that is perfectly appropriate, and they couldn't settle the case. We end up getting a tax court opinion on it, and that's what the tax court said. That's exactly right. You get to run it through the tax mill again.
Does this overall really prove in a situation like that always get advice from an attorney, ag law or tax law attorney.
Yeah, and the nice thing about this, Greg, is that attorney had heard me speak numerous times over the years and called me, and just to confirm he needed some backup support on this, or if he was missing something. And I told him, no, you're right. The other interesting fact about this one was Judge Paris, who was on the tax court at the time. She just retired. She and I have known each other for many years. In fact, in some instances, we kind of started out our careers not together, but working on some of the same things when I was in Nebraska and she was finishing up her graduate tax program in Denver. And she told me after the fact that she always had her research assistants pull whatever I've written and put it on the top of the research stack. And in that stack she gave them was an article that the lead attorney in the firm that hired me right when I was coming out of law school, who was the guru on farm accounting at that time and farm tax. That was the lead article, and then some of my other stuff later on, years later. And she said I gave that to the judges that had that case assigned to them, and they used that in that opinion. In fact, cited the cash accounting article that the lead partner in the firm out in North Platte, Nebraska, had written years ago.
Often large ranches and dairies that are on an accrual method of accounting assume the cost of cattle and cows must be capitalized and depreciated. Mm-hmm. But that assumption may be only partially correct?
Yeah, most farming operations are on cash accounting, but the big operations, many of them, large ranches, large dairy operations, are often on the accrual method of accounting, and that is helpful to them from a tax standpoint. I won't get into the weeds on why, but that is. And so the question is, do they have to capitalize or depreciate the cost of cattle and cows? Well, how do they handle this if they're on the accrual method of accounting? If they're purchasing the cows for dairy production or breeding, well, the normal rule is that you can't get a current deduction. You have to capitalize those costs and write it off. So the cost to raise calves born on the farm can be, however, expensed as that cost is incurred. And what I'm pointing out here is you can do that even if you're on the accrual method of accounting. And I think some dairy farmers and ranchers may not realize that. As long as you're not a tax shelter, and there are special rules for tax shelters, very few farms are. Some of the big ones might be, but very few are. As long as you're not a tax shelter, then you're going to be okay, and you can get a current deduction for that. But the animals have to be used in a farming business, and that's usually not a problem. As long as you're in the trader business of farming, you're fine, farming or ranching. If you are processing milk on the farm, that's where IRS is going to argue, well, you're not really in farming. You've got processing activities, so we're going to shove you out of this special tax rule. And I would carve that out, Greg. That's probably about the only thing I would carve out. If you're processing milk, if you're packing beef on the farm, then we've got an issue as to whether you're in the trader business of farming. But you might be able to avoid capitalization, even if you're on the accrual method of accounting for the cost of those calves and cows.
As always, every couple of weeks, we talk ag law and taxation law issues. Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us. And taxes, of course, you have to file plenty of forms. And one, as you termed it, is the filing of false forms or the 1099 miscellaneous forms.
Yeah, this is an information form that gets filed with the IRS. You don't pay tax with this form, but if you have somebody do work for you and it crosses a certain threshold, then you're supposed to issue a 1099 miscellaneous. It's just so that IRS can track these payments that were made to self-employed individuals, sole proprietors, those types of things, contractors that do work for you, as well as some service businesses. But we had a case last year. It came out of Nebraska. It involved a couple of farmers. And what you had was a farmer that bought another farmer's land at a court-ordered tax sale. And then shortly thereafter, he starts getting these Forms 1099 miscellaneous that added up to $15 million. So the IRS is getting a copy of that, and it says this guy received $15 million. And, of course, he hasn't, and so nothing has gotten reported. And so he's fearful, I'm going to get a tax bill for multi-millions of dollars. So he hires a law firm, and what had happened was that the guy that lost the farm got upset because his neighbor got it at the tax sale, and they hated each other. So to retaliate, he issues them these false 1099 miscellaneouses, just thinking, well, I'll create a tax problem for him. I'll get back with him. don't do that, because there can be severe penalties if you issue false 1099s. And what happened here was the court did impose a per form penalty, and there were lots of these false forms that were filed. And it was the greater of $5,000 or actual damages per form. This was huge. And the court said that the IRS documentation on a 1099-C needed to be filed to show that it was actually zero, so that he wouldn't get hit with penalties from the IRS, the guy that got issued the 1099s. So if you get upset with someone, don't think that you can create a tax problem for them by filing a phony 1099 miscellaneous. It might come back to bite you, as it did in this instance.
A big bite.
Yeah.
In this case too. There is a new law at the beginning of this year, reporting requirement that kicked in for many businesses, and that's, I guess, part of a law designed to crack down on the use of shell corporations, which, of course, are done to evade paying taxes.
Yeah, this is part of the Financial Crimes Network, which is a branch of the Treasury, so it's tied into the IRS. And if you've got a business that is registered with the state, so if you have a registration requirement with the state, Secretary of State's office, for example, in Kansas, this new rule is going to affect you. And there are filing deadlines. But basically, if you were in existence as of the beginning of 2024, you have to file these reports with the Financial Crimes Network by the end of this year. I've got to file my own report. I haven't done that yet. I'm kind of waiting to see what the courts are going to do on this, because it's being challenged as unconstitutional. The question has come up, and the states are starting to address this, is whether the preparation of the forms and the filing of the forms constitutes the unauthorized practice of law. So the question is, can your tax preparer, your CPA, your accountant prepare this, or does it have to be done by an attorney? And we're getting kind of mixed results at the states. New Jersey has come out. Their unauthorized practice of law committee said, well, if it's simple, let's say that we have a single member LLC, they have to register with the state, but it's really a sole proprietorship. If it's pretty simple like that, you have to report the beneficial owner. Non-attorneys can fill that out and file it. If it's complex, they said, no, you need to advise the client that they need to see an attorney to have this work done for them. Iowa, on the other hand, is preparing to send a proposed rule to the Supreme Court in Iowa that says it's always the unauthorized practice of law. So it doesn't constitute practice of law. Anybody can do it. A CPA can do it. An accountant can do it. I have trouble with that because there are some really complex situations, particularly if you have a trust that owns a business interest. The trust language will have to be analyzed. So we'll see what the Supreme Court in Iowa actually does with this. Now, what I would tell people, for example, farmers, there are exemptions. And basically, if you have more than $5 million of gross revenues for the year, you don't have to file. So if you're under that, you have to file. So that seems reverse. It seems backwards. But the larger ones already have a filing requirement under a different law. The smaller ones do. So if you have your farming entity that happens to be exempt, you may have some other entities that are tied to it, such as a land LLC or a machinery LLC, and that may not necessarily be exempt. So you need to make sure you're aware of this. Talk to your tax professional soon and get in line to get these forms prepared, and we'll wait to see whether the courts say that it's valid or not.
Well, and especially along the Kansas-Nebraska-Iowa border, may own land in Nebraska.
Yeah, you may have a filing in both states.
Yeah,
it's possible that you have an entity in both states.
Yeah, all right. Let's move on to another one, and we're in Kansas. We see lots of blowing dirt, and whether or not, of course, it's a liability or not, because you've seen accidents, traffic accidents that result in injuries or death, but that's obviously the point here in the legal question. Is that farmer or other rural landowner responsible for injuries or death resulting from accidents where blowing dirt comes from their field, and if that's a factor or not?
And creates a visibility issue, yeah. And we also, I get three types of questions on this, Greg. One is, for example, I've got a tree on my property near a road, and it falls over onto the road, and somebody runs into it. Am I responsible? Answer, generally, no. Not if you didn't have any indication that the tree was bad. It looked like it was good. I mean, you're going to have to hire an expert to testify to that fact, that the tree was healthy and so forth, and you weren't on notice that it was rotten. So that's one. Another one that I get, and we've had these cases come up in the Flint Hills over the years, and that involves blowing smoke over the turnpike, for example. If you remember, what was it, 25, almost 30 years ago, the Matfield Green incident on the turnpike. I think that was almost 30 years ago. Tragedy. Am I responsible? Well, the answer is depends. And were you in compliance with all the KDHE regs? And did you conduct your burn right? Okay. Kind of similar thing with respect to blowing dirt. And we get this one. It can happen any time of the year, but particularly in the spring and harvest time and in the fall, or in the planting time in the spring, harvest time in the fall, when you got exposed soil. Am I responsible if that blows across a roadway and causes some type of accident or fatality? Again, general rule, no. And in fact, we have a soil conservation law in Kansas that requires you to do certain things. So you need to be in compliance with the soil conservation law. You need to be in compliance with the conservation plan for your farm to start with. If you're not, that can open up the potential for liability in those situations. So general rule is no, but as in many situations of the law, it may not be black and white. Yeah, there may be exceptions.
I don't know if there's ever been a case on that, but growing up in Southwest Kansas, one of the things we had, and not necessarily in the spring, but, well, sometimes in the spring, it's tumbleweeds. And you get a whole bunch of them going across the road, and you might try to avoid them or, whatever the case is. And they're not little tumbleweeds. They're big tumbleweeds.
I remember, Greg, when I first it was Barry Flinchbaugh that called me years ago to come to K-State in 1993. And I thought it was odd at the time, and looking back on it, it was very wise what he did. He said, I want you to go around the state. I want you to go spend a day with county agents in certain areas of the state. And he sent me clear out to Hugoton. And Gary Gold was the county extension agent out there at the time. He's since retired. And I remember, Greg, he took me to lunch at a cafe in Hugoton, and on the wall were the pictures from the 1930s where it was black and it had the time on it, noon or 11:30 in the morning, and it's pitch black. So soil erosion is a problem, but starting in the 1930s, we've had conservation laws come into play, and with the 85 Farm Bill, you have to have a conservation plan in place. So that's where we want to start analyzing this issue is, are you in compliance with a conservation plan? Are you in compliance with the Kansas soil conservation law? And then we'll go from there.
Laughingly, I asked this. This is just probably the tip of the iceberg on the number of issues you get weekly that come up like this.
Oh, I had one, Greg. Some of the listeners in Osage County will appreciate this. This was May of last year, May of 23. I was in my law school office grading law school exams, and the phone rings. And I was happy the phone rang so I could stop reading this stuff from the students that they wrote for their exam. and this farmer tells me, he said, well, I got a fence issue. And of course, I'm thinking, all right, I've heard all the fence issues that are out there. This will be easy to deal with. And the conversation went on 10, 15 minutes, and I'm thinking, this isn't a standard barbed wire fence. What's going on here? So I asked him, I said, what type of fence is this? He said, it's a quarter-mile long, and it's a 6-foot high board panel fence. I said, you're out in the country?
Wow.
Yeah. Why is there a board panel fence?
Yeah.
He said, well, on the other side of the fence, it's a nudist colony.
Okay.
And so I asked another professor. I told him the story. He said, yeah, there is one. You can find it right off Highway 75. There's a sign that points to where it's at. Oh, my goodness. I had never had that one before. So we sorted that out. They wouldn't fix the fence. And I suggested, well, you could call the county commissioners out for a view. That puts that in a whole different context. Or you could just go fix the fence yourself and forget it.
Oh, my gosh.
But I get all kinds of stuff, Greg.
All right. Amongst these and other topics, they can go to your blog to get more information.
That's right. washburnlaw.edu/Walter, WALTR, and I also share it with Ag Manager over at K-State.
Sounds good. Roger, as always, appreciate it. Thanks.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW.